Everybody, I'm really glad that we're able to discuss this topic today. We have assembled a very knowledgeable crew to discuss civil asset forfeiture in the panel entitled Policing and Property Rights, What's Next for Civil Asset Forfeiture? So what I'd like to do, the format I would like to engage in, is simply, we'll do a brief introduction. I'll introduce everybody proceeding down the panel, and then we'll engage in moderated discussion, have a very organic flow to where we would like to take this today. And hopefully that'll stimulate y'all to actually come up with questions that'll further move the conversation. So without any further ado, allow me to introduce immediately to my left, Hal Stratton. Hal Stratton is the former Attorney General of the state of New Mexico, and we'll be asking him today about some of his experience with civil asset forfeiture in New Mexico. Hal also is a co-founder of the Rio Grande Foundation, the free market think tank in New Mexico, and most importantly, I would note that Hal is a right on crime signatory.
That's true. It's not in there, is it?
No, it's there in pen.
Okay.
Nelson Bunn is the Director of Policy and Government Affairs for the National District Attorneys Association. Prior to that, he was in private advocacy, and he also served time as on the Science and Technology Directorate at the Department of Homeland Security. Darpana Sheth is an attorney for the Institute for Justice. She has actually litigated these cases, and she will be providing a perspective on some of the, where the rubber meets the road, some of the actual battleground tactics that that she's had to apply in litigating this issue. Prior to the Institute for Justice, she served as an assistant attorney general in the state of New York, and she also clerked for Jerome A. Holmes on the U.S. Court of Appeals. She's a graduate of the Georgetown Law Center. And last but certainly not least is John Malcolm. John Malcolm is the director of the Edwin Meese III Center for Law and Judicial Studies at the Heritage Foundation. Prior to that, he was actually an assistant U.S. attorney for 10 years, and he also was a deputy assistant attorney general in the criminal division. He is a graduate of Columbia College and Harvard Law School. If we can we get a brief round of applause for our panelists? So John, diving right in, we're here to talk about civil asset forfeiture. You've written ad nauseum on the topic. Can you give us a little history on the practice and how it came to be used as it's used today?
Well, civil asset forfeiture is a very ancient lineage. I mean, going all the way back to the crown, where they used to have corruption of the blood and forfeiture of estates. If you committed an offense against the crown, your progeny were all deemed to be corrupted, and your entire estate was forfeited. In this country, it really began with admiralty and customs law, so that when a ship would come in, if it had contraband or duties weren't paid, and the cargo owner or vessel owner wasn't there, the ship would be forfeited. And largely, civil asset forfeiture stayed under admiralty and customs law. There was a bit of an uptick during Prohibition when they would take the vehicles of bootleggers, until the early 1980s when, as part of the war on drugs, Congress dramatically expanded civil asset forfeiture. It was to go after the assets of the bad guys, either the fruits of the crime or property used to help commit the crime, facilitating property, designed to deprive those bad guys of their profits and assets. And it has not remained only in that realm. There are now over 400 federal statutes that allow for forfeiture, and a ton of state statutes in virtually every state that allow for forfeiture. And again, it's premised on the fiction that the property itself is guilty of a crime, and it is designed to seize that property and deprive bad guys of their ill-gotten gains.
Excellent. Darpana, you've testified before Congress on this very subject somewhat recently. Can you explain how civil asset forfeiture is used at the federal level and how that differs from how it's used in the states?
Sure. So at every state, as well as the federal government, has their own forfeiture laws. At the federal level, there's what's known as administrative forfeiture. So basically what happens is property gets seized, and it's seized on the ground by police officers' determination that there's probable cause that the property itself is linked to criminal activity. Then the burden is on the property owner to affirmatively file a claim and say, no, I want my property back. If they fail to do so, the property gets automatically forfeited, and that's known as administrative forfeiture. And most cases, it's almost 70% of cases, are done administratively. If the property owner timely files a claim, then the government has to file a forfeiture complaint against the property, and it gets into the judicial proceedings. And at that point, the burden is on the property owner to affirmatively prove that they are innocent and that they didn't know about the underlying illegal activity. And so it really turns the presumption of innocence on its head. And then, I guess during that process, if they actually go through and win, eventually they'll get their property back. But because it's a civil proceeding, as John mentioned, there are no rights to counsel. Often the state laws, especially at the state level, there's no right to a prompt hearing, and so it's really a procedure that stacks the deck against property owners. And perhaps worst of all, it's the profit incentive. So at the federal level, 100% of the proceeds from forfeiture get returned directly back to law enforcement. And there's a special program, and this is how it interacts with state law, called the Federal Equitable Sharing Program. And under this program, state and local law enforcement can team up with federal authorities and essentially seize property under state law, and then simply refer that forfeiture action to the federal government to prosecute. And it could be, again, through administrative forfeiture, or if a timely claim is filed, through judicial forfeiture. And in exchange, the state and local law enforcement get up to 80% of the proceeds. So it really creates this direct financial incentive to sometimes circumvent even stronger state laws. And at the state level, every state has their own forfeiture laws, but the Institute for Justice has kind of ranked all of these states based on the protections they provide for innocent owners, like who bears the burden and how strong or how high that burden is to prove that property is subject to forfeiture, and then who gets the proceeds. Does the forfeited money go directly back to law enforcement, or does it go to a general fund? And most states, unfortunately, I think 36 states get a grade of D- or lower.
So Nelson, many prosecutors, including the current U.S. Attorney General, have called civil asset forfeiture a useful tool. Sure. And understandably, it could be used to target and dismantle criminal enterprise. Could you explain how would that happen? How would this particular tool be used to target and dismantle criminal enterprise?
Sure, so you're right. It is seen among prosecutors and other law enforcement organizations as a tool to dismantle criminal organizations. There are several instances where civil asset forfeiture, for example, would be useful. Because a criminal procedure would not be available. Look at the Ken Lay example with Enron. He died before trial. Civil forfeiture was what was used in that case to recoup money for compensating victims. Michael Vick, the dog case, 52 dogs were forfeited and then adopted by individuals to get that back. There are individuals, if a fugitive, for example, that might escape outside of our country. Civil forfeiture is the main mechanism to recover assets for victims. Third party, for example, oftentimes property or assets will end up in the hands of a third party where it's not appropriate to try to prosecute that individual. And so civil forfeiture is another mechanism to recover that property.
Excellent, thank you. Hal, you were integral in the reform effort that went through in New Mexico. Can you tell us a little about that?
Well, yes, we had, in the early days when I was a young legislator in the late 70s and early 80s, I was instrumental in getting the whole asset forfeiture system put in New Mexico. And I had a buddy by the name of Brad Cates who was there as well in the legislature, and he went on to the federal government, and then he went on to the Justice Department and became the head of the Civil Assets Forfeiture Division. So he was egging me on to put all this in place, and so I worked hard to do it. I then became Attorney General in New Mexico and continued to do it through the 80s. And I might add, both of us were the people you hear about, and I won't say lock them up and throw away the key types, but we re-sponsored the death penalty. We sponsored all the mandatory sentences. We sponsored the recidivist penalties. And so we were pretty hardcore, and we were pretty favorable to law enforcement. And then over the course of the years, when we got out doing other things, we began to notice that in a lot of situations, civil asset forfeiture was not being used for what Nelson is talking about. It was being used to make money and that the money was going into police or going into police department accounts, and there's no accountability. In Albuquerque, I have no idea, and I don't know anybody that does, how they spend the money that they forfeit over DWI. So anyway, this was a concern to us. And not to drag it out too long, but it so happened that Brad ended up being the chief staffer on the New Mexico House Judiciary Committee. And so he had some time to work on this and put it together. No way we could have done it without him, because he knew the nuts and bolts. They put it together. We talked the Judiciary Chairman into sponsoring it. And Republicans had taken over the House for the first time since 1952. So these were our buddies that were doing this. And we went to the first committee, and at the first committee, those who supported the bill were the Drug Policy Alliance, the ACLU, the Institute for Justice, the Rio Grande Foundation, which you mentioned, which is our kind of Texas Public Policy Institute in New Mexico, and then me. And I got up and I told him this same story I'm telling you, and I said, I'm just asking you for redemption here. I'm sorry about what I did. I wish you would please correct it. And then the new Speaker of the House made the motion to pass the bill. And I figured at that point, maybe we had a shot to get this bill through, because maybe it was really resonating. And so we got it out of that committee. It went pretty much passed through the rest of the House behind the scenes through consent. It consented out of the House Judiciary Committee, got unanimous vote in the New Mexico House of Representatives on the floor, went to the Senate, didn't go anywhere in the Senate, and then on the last day, they consented it out unanimously on the last day in the New Mexico State Senate, so we got the bill passed. The governor had 20 days to sign it. There was a lot of concern about whether she would sign. She's a career-long prosecutor, very passionate about her prosecutorial history. She's been a great one, and she's a great governor, by the way. And her husband happens to be the former undersheriff of Las Cruces down in Doña Ana County, Las Cruces, New Mexico. So there was a lot of concern about where she stood, and she got enormous pressure from the law enforcement community to veto it. But to her credit, she signed the bill, and it's now in effect. So that's believe it or not, that's the short version of how it came down. But
So John, you were a former assistant U.S. attorney.
Yep.
You direct the Mies Center at Heritage. You guys are not for drug legalization. You're not soft on crime. You're even the chairman of the criminal law practice group at the Federalist Society.
I am.
What motivates your involvement in the reform advocacy on civil asset forfeiture?
Well, look, I do believe in procedural fairness. So let me say that this is not about depriving law enforcement officers of the funds they need to do their job, although it may have that effect. So I believe that the overwhelming majority of public servants whom I've dealt with, law enforcement officials, are honest, ethical, and hardworking, and they operate in a very, very dangerous environment. And they should not only be adequately funded, they should be generously funded. The problem is with asset forfeiture as a vehicle for doing that funding is, first of all, it's totally outside of the appropriations process. So there's none of the back and forth about competing needs. There's virtually no transparency about how those funds are generated and how they are spent. And it is also an instance in which law enforcement officers largely get to control how much money they get through the actions that they engage in. There's this profit incentive that Darpana talked about. So for instance, if I were a judge and it was determined that my salary and the budget for my office was determined based on how many criminal fines I imposed and the size of those criminal fines, everybody would look at me and say, well, that's not fair. You know, one could question your objectivity in terms of your actions by operating in this sort of way. And I think the same thing applies with respect to asset forfeiture. I want law enforcement officers to be generously funded, but here you have a system where procedurally it is completely skewed in favor of law enforcement. I'm even prepared to acknowledge that probably the vast majority of these cases are meritorious. But because of the dollars and numbers of cases that are involved, there's a big risk that innocent property owners are going to be caught up in this system. It happens all too frequently, and they're screwed. And because law enforcement officers get to take advantage of that system and keep all of that money, I think it is unfair and has even on occasion been documented to warp law enforcement priorities so that they end up spending a disproportionate amount of time chasing the cash that is generated from crime rather than trying to stop the crime and catch the criminals on the front end. So this is not, in my mind, about depriving law enforcement officers of the funds that they need. It is about coming up with a fair procedural system that makes sure that the funds are really being taken from criminals and pretty much only criminals, and then having some accountability as to how those funds are utilized.
Certainly, and I think that we all have seen some of the more pernicious horror stories, be it from in Tenaha, Texas, or cases where certain offices bought margarita machines. I've been lobbying the brass at TPPF to allow us to buy a margarita machine, and we have not made much progress on that. But this all illustrates this corruption of incentives, and not necessarily a moral failing on the part of law enforcement or the district attorneys. But with that in mind, Nelson, what would be a good way of addressing some of the concerns that Darpana and John have brought up, but without compromising a district attorney's or a police department's ability to do its job?
Sure. Well, both John and Darpana brought up the incentive that law enforcement has in this. Darpana is absolutely right that through the equitable sharing program, for example, 80% can go back to the local agency that participated in that task force at the federal government's sort of invitation. What I want to push back on, though, is oftentimes, especially cases where a lot of victims are involved, like a fraud case, for example, that an agency doesn't know going into an investigation how much they would really get from equitable sharing. And so if you look at some of the larger cases that are heavily victim focused, there oftentimes is zero money that comes out of that through the equitable sharing program. So if law enforcement agencies that were participating in task forces were basing their decisions on investigations on how much money they were going to get, they wouldn't choose to go after some of these cases if that was their main incentive. So I think that based on that you de-link a little bit that perverse incentive that is oftentimes used. On the cost side of it, when an agency puts a body from their agency onto a task force, for example, they're obviously using money out of their own budget. So talking to my members about this, they feel that they are trying to recoup some of those costs that at the invitation of the federal government that they're using their agency budgets on. And so they do not see it as policing for profit or trying to go after as much money as possible. We also saw, I know a lot of critiques have been about the smaller cash amount seizures, for example, that before oftentimes were gone through state adoptions, which was the process by which a local agency could seize something and go straight to the federal government, sort of bypassing their state forfeiture laws. Just as sort of a historical background, originally the federal system was sort of created when states didn't have their own laws. Now, as Darpana had mentioned, all the states have them, and they all vary pretty widely, ranging from direct money going back to law enforcement to states that have their asset forfeiture go through school funds, for example. But with the elimination in January by the Department of Justice of state adoptions, we have seen in the first 8 months of this year compared to the first 8 months of last year through state adoptions, about $38 million in seizures the first 8 months of last year, down to $1.5 million in the first 8 months this year, with 1.4 of that being part of the public safety exception that was in that guidance in January that is firearms, ammunition, and explosives. For being able to seize those. So the numbers really don't lie in terms of the fact that policy has been put into place to change some of that, and it's clearly being very effective.
That is true. The Department of Justice has administratively changed how it handles adoption seizures. But wouldn't that be able to be undone on a whim?
Sure. I mean, it's an internal policy decision. You're right. And we have seen numerous, both on the House and Senate side, efforts to sort of reform aspects, both procedurally and on the financing side. But you're absolutely right. That's an internal policy decision, the same thing that they did with structuring. They put out guidance on structuring, and with the equitable sharing program, our organization, along with other national groups, are more than happy to continually talk with the department and other stakeholders on both sides of the argument to find out ways that we can sort of come to middle ground to tweak the system to make it more fair. We all agree that we need a fair system, and we would not disagree that there aren't bad actors. The stories you see in the media, absolutely bad examples, and we would not shy away from that. But as John said, the majority of these are done the right way. And to Darpana's earlier point on the innocent owner situation, she's right that the innocent owner argument is having to prove that that's your property. But first, the burden's on the government to connect that criminality to that property or the assets in question. So there are a number of sort of checks that are already there too.
Certainly. Now, Darpana,
Derek,
Can I just correct something very fast? Because Nelson
Please,
just said
by all
actually
means.
that I said that they were done the right way. I didn't say that exactly.
Well,
I said I thought they were meritorious cases
Right.
in that the government could prove that link. I still think the procedures are skewed. I think that the government would prevail in the vast majority of these cases if the procedures were to be made more fair, but the procedures need to be made more fair.
certainly Darpana, you as well.
Yeah, I was going to say going back to the equitable sharing program, adoptions were not eliminated under that policy. And as Derek mentioned, this is simply a policy change that can be undone by the stroke of a pen, and it needs to be codified in order by Congress. And so far, that has been stalled. That effort to enact reform through Congress and both the House and Senate judiciary has been stalled by opposition from law enforcement. So the question really is, why can't we abolish equitable sharing? If states have their own laws now, there's no need, back as there was back in 1984 when equitable sharing was created, to incentivize state and local law enforcement to participate in these actions. And moreover, adoptions only account for, I think it's 17% of all of the cases. So this idea that, well, we've solved a lot of the problem and it's gone down is not true. Most of the seizures are done through joint task forces. And in fact, the Washington Post series that came out last year looked at 62,000 seizures done since 9/11. And that they collected over $2.5 billion in cash seizures, all without any warrants, all without any indictments. And so it really begs the question of, well, what is the purpose of this? If we really are trying to deter crime, then why don't we use criminal forfeiture? The examples that Nelson used about Michael Vick's pit bulls and people who die before trial and therefore they can't use criminal forfeiture are really one-offs. They're not the run-of-the-mill 62,000 kind of cases that happen with cash seizures. And that's exemplified by the clients that we represent. We had an individual, Russ Caswell, who had a family-run motel in Tewksbury, Massachusetts, and over the course of 5 years, there were some drug crimes that occurred on his property, usually third parties, renters, dealing drugs or using drugs behind closed doors, all unknown to Mr. Caswell or his employees until after the fact, after arrests were made. But the U.S. Attorney's Office in Massachusetts went after the Motel Caswell. Why? Because it was a small mom and pop kind of operation. It didn't go after the Motel 6 down the street where there were similar drug crimes. And that's really where you get those incentives. And it's not, for example, what really happens is sort of that rationale to deter crime is distorted, and instead the incentive is to fund the agency and fund the agency's budget. And that can be seen by sort of the policing tactics. In Tennessee, for example, there was a great investigation into showing how many times the police patrolled which side of the highway. And it found that law enforcement in Tennessee were 10 times more likely to patrol the side of the highway in which money was flowing rather than patrolling the side of the highway where drugs are flowing. And that really gets to, so it's not about bad actors, it's about these bad laws that create bad incentives.
So Hal, as you've described, you've pushed through we're equitable on a bill in New Mexico that is definitely one of, if not the most sweeping reform pieces of legislation in the United States. we're a little bit removed from that now. Has the sky fallen?
No, by the way, the skies are the best in New Mexico, so anybody that wants to come to New Mexico and enjoy the skies, please do it. No, the sky hasn't fallen. However, we've got some issues still. And one of the issues is our municipalities don't want to abide by the concepts that are the fair concepts that Nelson and I were talking about earlier when it comes to their forfeiture, particularly in regard to DWI, and they don't think the law applies to them. The other thing that is of concern, this is the whole thing on the incentive concern. One of the big issues that we dealt with, there wasn't a lot of opposition to our bill at the time. We had the tide was with us, and there wasn't a lot of opposition. But some of the opposition by law enforcement was, we depend on this money, and if you take this away from us, we're not going to cooperate anymore in the joint task force. We're not going to go after the drug dealers. That tells you that the money is the incentive, because why would they possibly? Are they saying they're not going to do their job? Are they saying I'm not going to go after criminals? I'm only going to do it when the money is available to do it. And it's just appalling to me of all these people I've worked with I started as a prosecutor in law school, for heaven's sakes. And of all these people I've worked through over the years, don't sit down and see that we're in this for justice. We're not in this to see who wins the case. And over the course of my career, I'm getting a little personal here and getting a little off track, but over the course of my career, as I've been through these various government jobs, and I was also, you didn't mention the chairman of the Consumer Product Safety Commission, which may be the nation's biggest nanny agency, but we did prosecutions there too. It's too much about winning the case, too much about getting the money, and it's not enough about seeking justice. Sometimes as a prosecutor, you got to dismiss a case. And I can guarantee you, Nelson's going to tell us that happens. It does happen. I dismissed a case against a sheriff's officer in Torrance County when I was Attorney General. It was horrific. The TV stations went crazy, but we did it because it was the right thing to do. Now, you don't see that happen very much. And my concern here is this, when we get into the whole asset forfeiture thing, it's more about getting the money, winning the case, than it is about seeking justice. And I think that more than anything has caused me to be so strident about the way I feel about this now. So I think what we're going to see, I don't know if we'll see an effort by the law enforcement in New Mexico to try to revise the bill. They're talking about introducing fixes in the next legislative session. We think it's fixed, so we don't consider anything, we don't consider a fix something that's needed, and also in the upcoming session in New Mexico, it's limited to financial matters and things the governor puts on the call. So they will have to get the governor's message down before they put anything that will revise this, unless they come up with some creative budgetary argument, which they could. But so that's what we're looking at. So the whole group now that was involved in this is now involved in trying to work on those issues as they come up. And it's interesting to me politically, of all of the legislators that we're having issues with now who law enforcement has come down on, it's been 100% Republicans. And as a Republican, that makes me feel bad for my fellow Republicans who I've worked with out there for 40 years, but they seem to be hammering the Republicans because we, I guess, traditionally have been more pro-law enforcement, and they're saying, what are you doing to us? So because we have a state Senate that is not Republican, we'll probably be able to keep what we have and probably won't see any changes next session. So I know I got way off your question, but.
Could I add one thing to that? Going back to the cost aspect. So under the federal statute, law enforcement, state and local, are reimbursed for the costs that they incur in any seizures, forfeitures, and participating in those drug task forces. In fact, there's a separate entire pot of money called joint law enforcement funding that they do get. So equitable sharing proceeds, the 80% they get, are on top of that. So it's not just reimbursing law enforcement. Equitable sharing proceeds are a bounty on top of that.
So I look out across this crowd and see a lot of people I know who are attorneys. Nelson, if you could, we discussed this a little bit offline. Would you like to discuss some of the, and you hinted at this before, some of the reforms that have been proposed, how that presents a bit of a procedural quandary for district attorneys just to do their job?
Sure. So one of the biggest discussions that's been happening both at the federal and state level is on the burden of proof, for example. Currently, through civil forfeiture, the burden is preponderance of the evidence, as opposed to in criminal, it's beyond reasonable doubt. And a lot of the conversations have been around raising the burden under civil forfeiture from preponderance to clear and convincing evidence. Our concern is that by raising that burden of proof, that you essentially help the more sophisticated criminals, especially those overseas, for example, or those that have enough of a sophistication around the criminal activity that they can insulate themselves through shell corporations, for example. And that by raising that burden of proof, you essentially make it very, very difficult to go after some of these bad actors. In some states, you've seen, Michigan actually the governor just signed their state bill, and they did raise the burden of proof, for example, to clear and convincing evidence, although there was opposition by law enforcement. And, that's one example. Another example, some have talked about sort of a post-seizure hearing within 10 days, for example, and that's been a discussion that's been happening at the federal level, where after a judge, for example, has already gotten, now sometimes there are warrant exceptions, but if a judge has signed off on a warrant and then under some proposed reforms, a judge would have to look back at the case, and if he or she decides that probable cause wasn't there for that warrant, they can dismiss that with prejudice, which essentially means that later they're not able to go after that case any further, for example. And so those are two examples of some of the conversations that have been had. And I think there's a general feeling or concern that even if there are smaller procedural changes in the program, that we as a law enforcement community may even agree with, that if you add all of that up at the end of the day, that you make it so difficult to even go after a case procedurally that a lot of bad actors are going to be sort of let off the hook because people just won't pursue some of these cases. And in talking to our members, they feel that is going to be an impediment if a lot of this goes into action. So,
John?
Yeah, look, I just disagree with that. Is it possible, anytime you raise a procedural bar, you make a procedural hurdle, there may be some people who will slip through the cracks. That's entirely possible. But also, by raising that procedural bar, a lot of people who are now innocent donors who are getting screwed by the procedural irregularities that exist will be protected. Now, it is possible through some sophisticated cartels, through the use of shell corporations, might be able to shield themselves in some way from ultimately being criminally convicted. I have a hard time imagining that is going to dramatically increase the burden of law enforcement officials to tie property to criminal activity. So we're still talking about civil asset forfeiture. And I still think in the overwhelming majority of cases, if that connection is clear, raising the burden to clear and convincing evidence is not going to be in any way, shape, or form an insuperable burden. And think about the alternatives of what it is that you said, Nelson, which is to say we're not going to have a preliminary hearing because, my God, we could walk in and have a preliminary hearing and a judge could dismiss the case and he could dismiss the case with prejudice. So the assets walk out the door. Yes, that could happen, and it probably will happen a small handful of times. The alternative, however, to not having a preliminary hearing is that the government seizes your property and they hold on to it for months or years. Now, what if this is your livelihood or your business or your ability to get credit? You are decimated, and you will have to settle to get any of that money back, even though you may have been completely innocent and had an eminently defensible case. So yes, if you raise the procedural bar, it does make the job a little bit more difficult for law enforcement. The question is, do the gains by raising that bar outweigh what you will lose? And I say, absolutely yes. Criminal law enforcement, and that includes civil asset forfeiture, which is a quasi-criminal proceeding, should not be about shooting fish in a barrel. And you know what? If you have to do something beyond shooting fish in a barrel, there will occasionally be some fish that will get away that arguably deserve to get shot. But it's a fairer system.
Well, the other thing on that is I don't understand why we don't have beyond a reasonable doubt for forfeiting my money. I mean, if you really want to make things easy, let's lower the criminal burden of proof down to preponderance of an evidence. That'll make it easy. but that's not the Constitution, that's not fair, and I just don't see why anybody should be able to stop me on the road going home, take my money, and then forfeit it because they've got a lesser burden than whether I've committed a crime or not. If I didn't commit a crime, and you can't prove I committed a crime, you shouldn't forfeit the money. Our whole basis, innocent until proven guilty, was my last recollection about what the whole system's based on. And this really is criminal. I mean, the fiction of going after the property is crazy to some guy who's traveling with his son through New Mexico who gets stopped, pulled over, has $17,000. They let him go and then call the Homeland Security and the Albuquerque police to pick him up going through town and then take him to the airport and drop him off without any money. I mean, that's the kind of stuff that's going on, and that's what we object to. If you got a way to solve that and preserve the things against the drug cartels, then I'd be on board 100%, but I haven't figured out the way to do it.
But this isn't a criminal proceeding. There could be instances, like Nelson says, in which you're not going to have an owner there for whatever reason. They could be a fugitive or have died, or be in a country without an extradition treaty, or perhaps a case gets dismissed in a technicality. And it's pretty clear, and the government should be able to prove it, and clearly can prove it, even by a clear and convincing evidence standard, that the property is tied to illicit activity. So I'm not so sure I'd go as far as that, but that's me.
Nelson,
But then to add to the lack of a prompt hearing, I think there's a misconception there, because at least when the judge, if there is a judge that makes an initial determination, it's all done what they call ex parte. It's a one-sided proceeding. The property owner doesn't have any rights to put forth evidence, and that's why a prompt hearing is necessary, because it affords the property owner a chance to at least clear his name and get the property back for the duration of the forfeiture proceeding. So you can imagine it's your car, or as John mentioned, your livelihood. We've had clients who've had their entire bank account seized for supposed structuring, which is basically the government doesn't like the way you deposit your money because it's deposited in frequent less than $10,000 increments. And instead, they don't have an opportunity to show that, no, they didn't actually, the money they have is legitimately obtained. It's not connected to money laundering or any kind of drug crime. And instead, the government just is allowed to take it and keep it for the duration of the forfeiture proceeding. And this prompt hearing would give them an opportunity to say, no, this is my affirmative proof that I am innocent. And that's harmed some of our clients. So they've had gas station owners or restaurant owners, and they can't pay their vendors in the meantime because their entire bank account has been seized.
Nelson, that's a three-barreled assault, we could say. I'd like to give you an opportunity to respond if you'd like.
I mean, I don't know that there's a whole lot. I mean, I sort of outlined the rationale behind a lot of this, and I think that you have to go back to the fact that there are checks and balances that are already in place in the procedure of how this happened, of how cases are taken.
What are those checks and balances?
Excuse me?
What are the checks and balances when the people
the
aren't
government already
represented
has-
by counsel?
No, the government, the burden's on the government first to prove the criminality, and oftentimes, not all cases, but oftentimes they've already gone before a judge to establish probable cause, and I consider those checks and balances, that they've gone through the warrant process.
Well, most of the cases, though, are not warrants. So the 61,000 seizures conducted on the highway are not warrants. The similar amount of times that happens on the airport seizures are not with warrants.
And
so
the highway example is a bad example, and I would not, I would not associate myself with the fact that is a legitimate example.
Oh, that's good. That's good that we
there are
can
a lot
get
of
rid of highway seizures.
But
We're making progress.
Those are the examples that
Right.
you brought up. And we have talked about whether or not the seizure threshold level should be raised. When we had a member testify back in February on the Hill, the last page of our testimony was a number of reforms that we thought could be implemented, raising the threshold level. Training is always very important around this. Oftentimes people don't know, you're right, the procedure that is behind taking some of these cases and whether or not they are doing the proper procedure. And law enforcement, prosecutors constantly want training for these aspects. And so, those are two examples of things that we highlighted in our testimony back in February that we can work to improve upon. And I think that anytime that conversations are held around civil asset forfeiture, we're having discussions right now on the equitable sharing program and ways to work to make that more fair and to get rid of the perverse incentive that oftentimes is brought up as a major critique of that. And that incentive aspect of it, we're trying to find ways that we can be proactive and meet in the middle to ensure that law enforcement is able to preserve, with task forces, for example, the information sharing and intelligence gathering at the local level that is very important to bring in the federal, state, and local partners together. Ways to cover, you mentioned the Joint Law Enforcement Operations Account. You're right, that is a separate program. Now in statute, that covers expenses and overtime, for example. It doesn't cover salaries. So that's one thing we've talked about at the federal level, changing that to allow for it to cover for salaries and just have that be the program. So those are just examples of ways that we have been actively engaged in trying to sort of make this a more fair and process throughout the entire system.
Well, we're starting to draw towards the end of our moderated part of the discussion. Before we conclude and go to audience questions, I would really like to get one last perspective from each of you. Let's say that you are given the magic policy wand with which you could change any item of any code, state or federal, that you could. So, John, what would your ideal policy shift be on civil asset forfeiture?
Well, there are several, and actually we put out a booklet called Arresting Your Property, which I would urge you to go to Heritage website to get, that has a whole list of potential reforms. If I could pick one, it would be to raise the burden of proof. It's just simply too easy now, and I do not think that a clear and convincing evidence standard is going to prove much of an impediment to the government in the overwhelming majority of meritorious cases, but it will certainly allow innocent donors to have a little bit more breathing room to be able to get their property.
Darpana.
Well, certainly to abolish civil forfeiture and replace it with criminal forfeiture. There's no reason why no one in America should lose their property without being convicted of a crime. But short of that, there are many reforms that could be instituted, principally to eliminate the profit incentive. There's no reason why law enforcement should be in the business of generating revenue. The fund should go directly back to the general fund and have Congress or the appropriate state legislatures have oversight and go through the appropriations process, how everything else is decided. And that would go a long way towards curbing the abuse. And then, of course, there would be procedural reforms like increasing the burden.
I only got one.
I got one.
She wished for more
Restoring the
wishes.
presumption of innocence. We'd want to increase the burden on the government, but also restore the presumption of innocence, because there's no reason why property owners have to affirmatively prove a negative. And so I think that's...
It is a magic wand, after all.
Yeah.
Hal.
Well, we abolished asset forfeiture in New Mexico, so that would be, I don't have to make this choice, actually, at this point, thank goodness. But I think if people came to me and said, well, which one do you consider the most important? It's the funding. It's having the non-appropriated funds go back to the police department or wherever they go. It needs to go to the state treasury, or maybe even to the city, if it's a city or municipality, to that treasury. I can tell you as Attorney General, I don't remember asset forfeiture ever coming up. Nobody ever came to my desk and said, hey, we're doing this, we're doing that. We didn't need it. We didn't use it. We still did pretty good, in my opinion. And every legislative session, I had to go over there, get my brow beat in on our budget. And that system's okay, because that way you have to go and justify what you need. And by the way, the legislators ought to give you what you need. You shouldn't have to be out there taking funds through civil asset forfeiture to fund the law enforcement department. That is one of the core functions of government, and the legislators should be taking care of that. But
Agree with that.
And Nelson, I wasn't deliberately skipping. I wanted to
Sure.
repurpose the question a little bit.
Sure.
As these reforms move forward, as they have in other states, what is the critical component that we do not overlook? That one is one of the components of the policy reform that is perhaps giving short shrift as it is now, that you would like us to pay attention from the district attorney's perspective.
Well, I actually would go along with your original question. I think decoupling the link through equitable sharing, we see as problematic. That now we have that operational day-to-day, that's how it is right now. So we're working under the confines of current statute and what is allowed under law. And so I honestly think we would agree that looking for ways to decouple that direct link between what is seized in a particular investigation and what is then given back to agencies is a very important policy matter that we need to review. And as I mentioned, those conversations are currently happening now to figure out if there is a way that we can sort of decouple that link while still making sure, as everybody I think agreed here, that law enforcement should get funded at an adequate level to do their jobs. And so I'm fine going with your original question, that we would like to find ways to work on that too. So
It is a magic wand. It's reversible.
yes, that's right. That's right.
So, ladies and gentlemen, a round of applause for our panel here today. Thank you all so much for giving us your time and expertise. What we'd like to do is we'd like to go into our audience participation part of the program. We have only one mic runner, so please bear with her as she tries to move about the room. And feel free to ask a question directly of one, some, or all of the panelists.
Hi, Jarrett Skorup. I work for the Mackinac Center in Michigan, and we did a lot of work on forfeiture in this past couple months here. A lot of help from indirectly from a lot of people on the stage, and directly with IJ was a huge help for me. I was fascinated by that last question because it was similar to my thoughts on this. So going through the process, I thought Michigan passed this. We were one of the lowest rated states, and we passed some bills establishing at least some basic transparency and raising the standard of evidence. What became clear to me pretty quick was the law enforcement side of it was willing. They dragged their feet a little bit, but they were willing to give that up as long as they could keep the direct profits. But one thing I realized going along was a lot of the on-the-ground problems that you see are when you have both systems, the civil and the criminal. Just having a system where you can take someone's property and then they have to go and challenge to get it back, it doesn't really matter what the standard of evidence is if they're still able to do that. And the equitable sharing, that provides a bad incentive. So I guess my question is, how big of a problem, particularly, Institute for Justice obviously does the most on this. How big of a problem is it just by having those two systems for the normal, everyday person on the ground that doesn't understand their rights, that even if they're innocent, they're just not going to go, and in Michigan, you have to wait a month to challenge it. You have to do it within a month, and then you still aren't going to have your property, and you have to pay the bonding and all these different things. How big of a problem is that specifically, as opposed to kind of those other problems, which of course we want to reform, but might be a little bit larger lift?
Right, well, that's an excellent question. I think that sort of front end, putting the burden on property owners to get their property back, both at the federal level through these administrative proceedings and depending on the state, whatever procedures they have, is a huge problem because, it is a civil proceeding. So all the guarantees that criminal defendants get are not applicable. They have to navigate a complicated system. I mean, most people have never heard of civil forfeiture, and they call it in rem proceedings. And they don't have counsel. And if they, a lot of times, even if they can afford counsel, it's not worth it because the value of the property will be less than what they've lost or what they would pay in legal fees. So that is a huge problem to kind of put the burden on property owners in the beginning, and having the two systems merge. So oftentimes it's not clear, well, the police are seizing it, now are they keeping it as evidence, or the property owner has to wait for 90 days or whatever the time frame is before they even get notice of the seizure and then can file a claim. And so that's an excellent point, that maybe we could bifurcate the two or have different procedures, or as Nelson raised, maybe even not getting rid of the probable cause standard at the seizure level. That would be a great reform.
There are a lot of technicalities too in those administrative proceedings, and if heaven help you, if you run afoul of one of them, your property's gone and you've lost the opportunity to contest for it.
Hi there, my name is Matthew Feeney. I work at the Cato Institute, and I'm wondering if any of the panelists would comment on how they think civil asset forfeiture has influenced law enforcement tactics and strategies. Has there been a shift in how officers behave, knowing that certain properties can be seized?
I think Darpana alluded to it. I alluded to it as well. There certainly appears to be instances in which law enforcement priorities focus on the property. So Darpana talked about this undercover investigation that was done by a news organization that said literally there was 10 times the amount of police force on the side of the highway where they would watch drug dealers come from Mexico, suspected drug dealers, and go to Nashville. And there was 10 times the amount of authorities on the side of the highway from Nashville back to Mexico. They suspected cars were coming up with the drugs. They allowed the drugs to be sold on the streets of Nashville and seized the money going back towards Mexico. And there are lots of stories like that. I've also heard anecdotal stories, for instance, of attorneys in local communities who will sit there and say, law enforcement authorities will sometimes in drug cases fail to show up for court. Cases will get dismissed. They never fail to show up for court when forfeiture funds are involved.
And another aspect to that is sort of the increased militarization of the police force. I think you have a lot of, because of this profit incentive, agencies can self-finance through forfeiture, and then they're not subject to congressional or legislative oversight. For example, there was a case in North Carolina where they do not have civil forfeiture. They've only have criminal forfeiture, and law enforcement were able to use the equitable sharing program to essentially buy a drone and things that maybe necessarily police officers or police departments don't really need. And so that kind of oversight check is missing because of civil forfeiture, and specifically the profit incentive.
There was a deputy sheriff in a county in Illinois who referred to civil forfeiture as he said, all of our towns are sitting on a tax-liberating gold mine. That's just wrong. That's wrong on so many levels that one can hardly know where to begin.
Nelson's point about how the government's role in establishing the criminality or the nexus between an alleged act and a piece of property is a sufficient check and balance. And we followed the Motel Caswell case that the Institute for Justice litigated very closely. And one of the interesting things about that case was how it started. And if I recall correctly, the DEA has a employee, and I think the employee is actually a contractor from a company called Forfeiture Support Associates. And what this guy's job is to go through newspaper records and look for evidence of crimes and arrest records and whatnot. And that's how I think the Motel Caswell case got initiated. This employee saw over in the Tewksbury newspaper that people had been arrested at this motel, and so that was the probable cause or the record that led to the investigation that eventually led to the U.S. attorney trying to forfeit this $1 million property. And so I really want to kind of ask you why you think that these kinds that this kind of system is a check in any kind of way, and what is being balanced here?
Well, in the Hotel Caswell example, I mean, I didn't know those details about going through the individual records and finding that. I don't think that's right either. And so, I wouldn't want to, I don't support, or my members don't support anything like that. But, I mean, we've talked about the innocent until proven guilty, and that it sort of turns itself on its head with all of this. And I think the Department of Justice feels, and our members feel, and law enforcement feels, that by having to establish first that those assets in question should be forfeited because of whatever situation they're in, that then that is a check before the owner actually has to prove that that was their property that should not be taken. And so and that's the basis of it. I mean, my members feel that is an appropriate check. They've already gone through to determine that criminality existed based on certain evidence, sometimes with a warrant, sometimes not, and it's gone before the judge for the warrant cases, and that is an appropriate check before it goes to the owner to determine.
My name is Judge Jim Gray. I'm from Orange County, California, and also a libertarian. And I agree with Darpana with regard to just have a conviction first and do it criminally as a halfway measure. In the meantime, you're probably aware that in many civil cases, the prevailing parties are entitled to their reasonable attorney's fees after they get their verdict. I would suggest to you that a good measure would be to allow the citizen or whomever to have their attorney's fee, reasonable attorney's fees in opposing this or getting their property back. I would not have the government entitled to their attorney's fees, but I would on the opposite.
Well, CAFR already does provide for attorney's fees, but there are a lot of loopholes in that. So, for example, the Department of Justice has brought a number of suits against our clients, and then they've seized the property, but before they filed the forfeiture petition, once we got involved, they returned the property to the property owner. And because of that, because there was no forfeiture petition actually filed, courts have said, well, I guess you're not entitled to attorney's fees. So there are some loopholes there, but it's an excellent point that the attorney's fees is at least some kind of deterrent. So if you can provide for them, whenever property owners get their property back, even if it's not prevailing all the way through trial, if it's at some point before then.
And that's also, I'll just add, in sort of the discussion that's going on right now with other federal legislation, looking at recovery of attorney's fees and sort of setting a threshold, and I'm sure everybody on stage is generally aware of this, but talking about sort of at what point that if a certain amount or a percentage is what it is, but of the assets are determined to go back to the individual, that if you cross a certain threshold, then they cover the attorney's fees, and looking at sort of where that threshold is. So a provision like that is being talked about again at the federal level to sort of determine when those attorney's fees should be reimbursed by the government. So.
It looks like we have time for one more question.
Thank you. My name is Shyler Engel. I'm an attorney in Michigan. I deal with medical marijuana, and unfortunately also civil forfeiture comes along with that pretty regularly. My question that I run into with clients of not a ton of means is the issue of the bond requirement in Michigan. They have to post a certain amount of money to even have their claim. I've always felt like the bond requirement doesn't have any moral justification at all. I think if there are multiple claims, we're going to compete these claims anyway. I'm pretty sure I know where two of the panelists sit when it comes to bond requirements. So I guess John and, and also Nelson, where do you guys stand on any bond requirements, if at all?
Well, we generally, if you look at your example with that, but just in general, like pretrial bond or bail, for example, we haven't supported sort of the cash system of whether or not you can pay as opposed to what your risk is to the community or anything like that. So we haven't done a ton in that space in terms of at the national sort of policy level. But in your example, I don't think we would not support sort of that bond mechanism. So.
I'll confess that I haven't spent that much time focusing on that particular issue. I mean, I do think that judges should be able to be involved in terms of making decisions like that and setting appropriate levels, and there'll be times when the bond may be appropriate and others when it won't be. But I can't say I've spent a tremendous amount of time looking at that aspect.
That's one of the first things that Congress got rid of in CAFRA, the bond requirement at the federal level. So it's surprising that there's still states out there who have this.
Well, that's about all the time we have today, unfortunately. We could probably rely on audience questions for another hour and a half, but I think that would just intercede with you on getting to dinner. So one last time, round of applause for our panelists, please.